world, trying to implement their very rigid and specific tradition worldwide. But what's the situation in Europe? There is some thousands of women wearing this niqab. Should they be prevented from doing so? And we know that there is legislation on that in France, in Belgium. There was an initiative in Parliament in the Netherlands, which was stopped. There was a short debate in Germany. I was myself an expert in the German Federal Parliament, but found out that neither of the parties, from left to right, were really inclined to introduce any new laws, since they said we have enough legal protection if this niqab is really detrimental to the common good. So, what is the argument of those who want to prevent the niqab in public space in total? We know from France that this was a political issue. It was simply promoted, trying to demonstrate, we are French, we will defend our culture, and these are the others, and let's prevent them from doing so. One of the major arguments in France was, it is simply impossible that a woman can accept such a garment willingly, without being forced to them. And I must admit, being part of the European citizenship, it is extremely difficult to communicate with women wearing such a garment. Because more than 50% of communication is not language, it's mimics, it's gestics, you don't see that. And very often this niqab, so-called necessity of wearing a niqab is explained by the exposure to male views. I must say, I'm not happy with the image of females and males alike by these people. Are women so weak that they need this kind of protection against men? And are men so weak that you can't distinguish them, and don't distinguish themselves from animals who would react very instinctively, maybe to meetings with the opposite sex, but I think still we are human beings, so we can protect ourselves and the others by other means. So in a way, it's a kind of, I would perceive it personally as a kind of offense in civil society. Why do they mistrust us so much that they think they have to hide in public like that? But why shouldn't they do it if they wish to do so, if they are simply walking in the streets? I mean, there are ways of being covered or of being uncovered in the streets which would not meet the taste of everyone equally, but this is civil society. There is a broad range of options, of perceptions, and as long as that does not endanger some legitimate legal issues, we have to grant freedom. Freedom of religion, freedom of behavior, and of course we could restrict this burqa or niqab or whatsoever in cases of security issues. Of course, if we want to control someone at the airport entrance, anywhere else, people have to remove this garment. I would say state officers couldn't wear it. I would even go so far that in all cases where communication is not only desirable, but indispensable for promoting the issues you have to promote, then you can legitimately prevent it. And I would include, for example, classes in universities. I want to see the face of those which I'm talking to, which I'm responding to. So I think we can draw the limits without endangering the basis of our common culture of security and communication. We do have freedom of religion. To come to the last point concerning religious rules, we do have freedom of religion not only in relationship between the state and individuals, these were my examples so far, but also in private matters, which means between private subjects, which is mainly relevant then from a legal point of view in labor cases. Why is it so? So the idea is, first and foremost, basic rights, fundamental rights, human rights are protective rights for individuals against the state. The state has to protect, has to grant these rights. These are the so-called liberal roots of human rights. But then we have second, third generations of human rights, and we have the idea that this set of human rights, this set of fundamental rights, creates a kind of normative order which should at least influence to a certain extent also private relations. So in private relations you may discriminate to a certain extent in the way that you have your own preferences. You are not necessarily forced to deal with everyone. The law forces us to obey the laws, to pay our taxes, but the law cannot force us to be nice people. So there is a broad scope of ethic, attitudes, of morality, of religion, of whatsoever, where a societal debate, a debate in society has to be conducted, rather than laws have simply to be implemented and imposed on people. Being a lawyer, I'm saying, and having been a judge at the court for a couple of years, there are so many conflicts in society which are not very well solved by courts, since you don't come to the roots of the conflict. You can decide a particular case, you have to, of course, if people are coming to your court. But in some cases, you know, if we don't reach a settlement here, this conflict will continue. And there are some conflicts and debates which should be debated in society. The law can impose, the law can force, but the law cannot necessarily convince. If we want to convince people, we have to debate issues in society, and of course we have at least to explain why the laws are as they are. And so in the sphere of private law, we do have some human rights standards, freedom of religion standards, but not to the same degree as in the relationship between the state and the individual. Why? Because the state itself is not granted human rights. It's not a bureau of human rights. It's simply a mode of organization, of transmitting interests, of balancing interests, but the state cannot claim human rights. So the individual, which can claim them, is in a relatively strong position. If we do have a conflict between employer and employee, concerning religious issues, for example, free time for prayer, etc., etc., there are two people in conflicting interests who both may claim their individual fundamental rights. The rights of the employer to maintain his or her enterprise, etc., the right of the employee to a certain extent follow religious convictions. And here we have to balance the interests. How important is this religious issue? How important are the interests of the employer, who of course has to run his or her enterprise? You can only decide that from case by case. I mean, there was a clear British case a couple of years ago, a bus driver in London, I think it was, who wanted to interrupt the bus rides for the ritual prayer, which is short, as we know, 5 minutes, 10 minutes you can do with it. But nevertheless, when the bus stops, the driver goes outside, praying mat, etc., performs prayer, and then the ride continues. Very often I had that when I was traveling in Oriental countries. No one cares. The time schedule is a suggestion rather than a fixed rule. And so no one really cares if the driver or some passengers wish to do so. They simply do it. But can you imagine in Leuven, in other places in London? No. And so it was very clear that this driver could not claim freedom of religion to this extent to interrupt public traffic in this way. Contrary case, labor court in Germany, there was a lady who wanted to perform the Hajj, the pilgrimage to Mecca, the one at the right time, so not the Umrah, which you can perform all over the year, but at the precise time of the Muslim year. Her job was to accompany children in a school bus, just to look for keeping the order within the bus, etc. And so her employer said, yes, well, in 14 years, the holidays will fall together with the time of the pilgrimage, and then you may go, but not now. And this lady, she was not too young. She had an old mother who cared for her disabled child. The the employee's child. So in 14 years' time, it was very unclear whether she would find anyone to care for the child as long as she is in Mecca, etc. And so the labor court said, well, why didn't you regard these needs of the woman at that time to perform the pilgrimage? Suppose if she were sick for 2 weeks, you would have to find an alternative for her. So it is not a big deal for an employer to, in such a big enterprise with so many employees, to find an alternative solution. And so the weight of her interest was disregarded, and therefore the termination of the contract was not accepted by the court. So these are just 2 examples which should try to demonstrate that you always have to look concretely at the case to be decided, and very often it's a kind of grade and measure. It's not black and white. The law, if applied concretely, is very much the gray zone, you know. So everyone has a point, and then you have the balances, and then you have to put them into that, and then at the end weigh up. So very often we don't have very strong solutions saying, oh, that's crystal clear, the solution, and the other one. No, very often people have their points, but at the end you have to weigh up by fair measurement. By fair measurement and by the necessary amount of self-criticism and self-conscience, how easily you can be biased in your decision by non-information, by wrong information, by your own experience. I mean, lawyers usually are trained to try to be objective. We know we can't be 100%, but at least we try to. But it's hard work. And very often you have this mix of dealing with phenomena which are religious ones, which have to deal with immigration, which have to deal with other things, and it's all mixed up. So sound information first. Sound information before deciding is indispensable. And we don't have until now the degree of sound information we should wish as it comes to some parts of Islamic normativity in our courts and institutions yet. And this was a part of our Religare project, a project I mentioned before, Marie-Claire Fabretz and others, to develop concrete suggestions to the European Commission how we could improve the system, getting more balanced decisions on basis of sound information, of applying sound measurements in design. A few last words to leave some space for the debate, of course, relating to possibly the most intricate aspect of Sharia in Europe, which is the legal part of Sharia. As I told you, Sharia, the system of Islamic normativity, contains religious as well as legal rules. So it's family law, it's contract law, it's tort law, it's penal law, it's law of evidence, and many other spheres who are regulated according to Islamic rules in a very different intensity. So it's mainly family inheritance, charities, which is the core of Islamic law nowadays in the so-called Islamic world. Why should we deal with such Islamic law? And by the way, I have to mention, this is not Sharia. This is state law derived from certain interpretations of Sharia, which are quite different according to the several schools, Sunni, Shia divides within the schools, etc. So if we are talking about Islamic law in the stricter legal sense, so norms applying here in this world with worldly consequences, we shouldn't talk about Islamic law or about Sharia, but we should talk about Jordanian law, Egyptian law, Moroccan law, Indonesian law, etc., etc. But why should we deal with these laws in Europe? Isn't it the case that in Belgium, Belgian law rules, in Germany, German law, in France, French law? Of course, that's true. That's true. The law in no single state in the world is multicultural, in the sense that we would recognize an equal value of conflicting legal orders. So one legal order has to have the right to last decision in case of conflict. And all the states in this world claim that their law of the land, which is given by the respective sovereign, has to decide on this last and most superior level. So if we apply foreign laws, we do that under our own legal system. It's not because the others claim that, it's because we, the legal order of the land of Belgium, of Germany, decides to do so. We don't do it in public law. We don't do it in matters where sovereignty is touched. Especially, we don't do it in penal law, since penal law has the function of granting a common minimum standard of conduct. So we cannot pluralize these rules in a way that, okay, there are victims first degree, victims second degree, other victims which are not protected at all because these people are living to their own rules. This would undermine the very roots of the basic function of the law, which is granting peace in society. And we do have this common minimum standard, this common measure of unity to grant peace in our societies. And every society has the right to define this common minimum standard, which is changing, of course, as we know. But nevertheless, as far as it is defined in a particular way, everyone has to keep these rules, and this is the public law issue. But then let's come to so-called private law. Private law as opposed to public law, or civil law, which regulates the relations between private persons, so its contract, its tort, its family, its inheritance, etc. So here the interests of individuals are of prime importance. And now we are living in an international world. We always did, but more than ever. In my country, for example, every fifth marriage is an international one. So spouses have different citizenships. And I think it's not very different in other countries in Europe. And so the question comes in, which should be the law, which is the appropriate law to govern these relations? Let's take the example of French people living in France for 40, 50 years, having married there, having grown up their family, etc., and then coming to Belgium or to Germany or to another country. Should we necessarily say, now that you are here, we apply Belgian law to you? Even in cases where Belgian law differs from French law, it's an example because there are so many similarities between the two, but in case of differences, we acknowledge to a certain extent that people rely in the creation and in living their relations that they are living under a particular legal framework. And that's why then they arrange their lives according to this framework. So should we change the framework just because they changed the borders? They changed the place of residence? Not necessarily. And this is the sphere of so-called private international law or conflict of laws in international cases, in cases where more than only one legal order is touched by the facts. We have to decide which is the more appropriate law to govern these relations. And then we could come under our own laws to the result that the more appropriate law is the law of France, or the law of Jordan, or the law of Brazil, or what country whatsoever. So this is nothing specifically Islamic law. It's the application, the scope and limit for the application of foreign law as such. And this is why European administrations and courts on a daily basis apply foreign law in these private issues, including law derived from Sharia, Islamic law, in the shape of state laws. But there will be limits, of course. The limits are drawn by ordre public, by public order, public policy, however you would call it. The French term is very widespread in science and practice. We have to limit the application of foreign rules in cases where the outcome of the application of this foreign rule, not the foreign rule as such, the outcome of the application of the foreign rule would fundamentally contradict our own rules, our own solutions. So then, if we have such a great disparity between the solutions, we cannot anymore enforce these foreign laws which would contradict our own convictions, basic convictions, and would thus undermine the necessary amount of cohesion of our legal systems. So we open the door for foreign law for reason of appropriateness, but we then close it if the outcome of the application contradicts public order in the sense of a concrete violation of the outcome as regards the convictions, the legal convictions of the law of the land. To give you a practical example, it's cases which are which don't occur very often, but which are always a part of the Sharia debate: polygamy. How to deal with polygamy, which, by the way, is not specific for Islam. We do have it in Southern Africa, we have it in Thailand, we have it in other cultures for various reasons. Nevertheless,